Now, after having discussed these important legal provisions, we also should understand and analyze as to what is the role of judiciary in sanctioning the scheme of merger. Under the Companies Act 1956, High Court enjoyed and still enjoys wide powers to sanction a scheme and approve such a scheme. The powers of the tribunal now under the 2013 Act, they include power to sanction the scheme, power to stay proceedings, power to reject or modify the scheme, and power to order winding up of the companies. Important case laws are required to be discussed here, which would help us to understand the role of judiciary in not only explaining the meaning of important terms, as well as also making us understand the entire procedure before sanctioning the scheme. One such important case is Saraswati Industrial Syndicate versus CIT Haryana, decided in 1991 by the Apex Court. It was held and the Supreme Court explained the concept of amalgamation. The court stated that in an amalgamation, two or more companies are fused into one by merger or by one taking over the other. When two companies are merged and are so joined as to form a third company, or one is absorbed into the other or blended with another, the amalgamating company loses its identity. There may be amalgamation either by transfer of two or more undertakings to an existing company. Similarly, another important case, General Radio and Appliances Limited versus M.A. Khadar, decided in 1986 by the Supreme Court. It was stated in this case that after the amalgamation of two companies, the transferor company acquires a new status and it is not possible to treat the two companies as partners or jointly liable in respect of their liabilities and assets. A very important issue which arises here is that whether anyone has a right to raise objection to the scheme or not. Now, because this entire procedure of sanctioning the scheme is based on a fundamental principle of corporate democracy, it is important to give this right to raise objection or make representation to the stakeholders. Now, there is a difference on this point between the Companies Act 1956 and Companies Act 2013. Whereas under Companies Act 1956, any interested party was allowed to raise objection at any stage before the court approved the scheme. Under the Companies Act 2013, only those shareholders can raise an objection who hold at least 10% of shareholding, or only those creditors can raise objection who hold at least 5% of outstanding debt. Therefore, the new Companies Act has provided a criteria for those people, for those shareholders, stakeholders, creditors who have a right to raise objection, and now it is not that anyone can raise objection anytime. This is just to make sure that there are not many frivolous petitions or frivolous applications for the rejection of the scheme that are put up or pending before the judiciary, before the court or before the tribunal. Therefore, now we conclude. Today under this module we discussed the concept, the meaning of corporate restructuring, various forms of corporate restructuring, the need for corporate restructuring. We also discussed what are the various forms of mergers, that is vertical merger, horizontal merger, conglomerate merger. Then we discussed the legal provisions pertaining to mergers and amalgamations under the new Companies Act 2013. And finally, we also discussed few relevant, few important judgments of the Supreme Court, wherein the court explained the concept of amalgamation, explained the concept of merger, and also explained various criteria. For example, it was laid down in Mihir H. Mafatlal versus Mafatlal Industries Limited, also in the case of Hindustan Liver Employees Union Limited, that any scheme of merger should not be against minority interest, should not be against public interest, it should be just, it should be fair, it should be reasonable. Therefore, these are various criteria which the judiciary, which the tribunal has to make sure of before approving or before sanctioning a scheme of merger or amalgamation.